Hello. As people are coming in, please feel free to introduce yourselves in the chat while we just give people a couple of minutes to come in. We'd love to hear who you are, where you're coming from, what you do. Hello, everyone. Please feel free to introduce yourselves in the chat. Let us know who you are, where you're coming from. It'll help us guide our conversation a little bit today, and welcome. Hello, hello, hello. Hi, Veronica. Hi, Jaime. Hi, Samantha, Anita, Monique. Good to see all of you. We have a lot of different people here. We're going to go ahead and also launch a quick poll. We have a series of couple of questions to learn more about who you are. Please fill this out as closely aligned as with what you do as possible. It'll really help Jeremy kind of guide the conversation today and figure out how 101, 201, or 301 he can be with you all. It's great to see all of you. We're just going to give people a minute to answer this one, and then we have a couple more questions for you. This is great. We have a lot of public defenders in the room, law enforcement, private attorneys, social workers, sentencing mitigation specialists, and investigators. That's fantastic. And service providers. Welcome to everybody. Hi, Jasmine. Hi, Jane. Good to see you all. Hi, Rod. All right, I'm just going to give this question about 20 more seconds since we still have some people coming in. And then we'll go to our next question. All right, I think this gives us a good idea of who's in the room, which is great. We have a lot of public defenders, sentencing mitigation specialists, and service providers in the room with us today. Let's go on to the next question. Let us know with this question if in your capacity in your job you've ever worked with or represented a survivor of intimate partner violence or human trafficking before. All right, lots of answers coming in. It looks like we have a lot of people who have worked with survivors before, some people who have not, and hopefully we will give you some good information in case you do. All right, I think it looks like 71% of the people in the room have worked with survivors before, which is fantastic. Let's go on to our next question. Hi, Kelly. Thank you for being here and thank you for sharing. We're so happy to have you here. Now we want to know if you've specifically worked with survivors who have faced felony charges before. We're getting some more mixed responses here. It's pretty even, neck and neck, 50-50. All right. So I think that's going to be about half and half. So most of the people in this, there's no clear inclination. We have 48% who have and 52% who have not. That's good to know. And one last question for you all. We want to know if you are familiar with or have ever worked with the defenses of duress and coercion specifically. All right, mixed responses here as well. Great. So it looks like majority of the people are not familiar with these defenses. However, quite a few people are. So that's good for us to know as well. Thank you so much for taking the time to answer those questions. We had 57% say no to that and 43% say yes. With that, let me take a minute to introduce our fantastic speaker with us today. We have Jeremy Thornton from the San Diego Public Defender's Office, and I've had the privilege and honor of working with Jeremy on AB 124 this past year, and Jeremy honestly wrote most of that bill. If we're being honest, he was the force behind the wizard behind the curtain who did all of the language pieces and a lot of the education pieces about what all the different provisions are where our survivors are missing help in the criminal legal system right now. Jeremy, as I said, is a deputy public defender. He's been working in that capacity for over 10 years. He is in the writs and appeals unit right now in the office and has litigated almost every type of criminal case. So we're so happy to have him here today to talk to us about the updates in the law and how to prepare the most effective mitigation packets to represent folks and survivors in this space. So without further ado, I will turn it over to Jeremy. And please feel free to
Thank you, Pallavi, and thank you everyone for coming. And thank you for the opportunity to share today. Today we are going to talk about effectively communicating that your client is a victim and not a criminal. Before we get into that, though, I do want to talk about Assembly Bill 124 and the statutory changes that it enacted. Pallavi was very kind. This was actually a very broad coalition, and a lot of people put a lot of work into this. And we're going to talk about exactly how the bill ended up and what provisions it affected and enacted. It added Penal Code Section 236.15, which is a vacatur provision for victims of intimate partner violence and sexual violence. It amended Penal Code Section 236.23, which is the human trafficking coercion defense. It added Penal Code Section 236.24, which is the applying that coercion defense to victims of intimate partner violence and sexual violence. It added Penal Code Section 1016.7, which deals with negotiations and what prosecutors must consider. It amended Penal Code Section 1170 along with a few other bills that, and it now really requires judges to consider certain types of evidence in a certain way. And it amended Penal Code Section 1170.03, which deals with resentencing. Today, we're going to focus on the coercion defenses. We're going to focus on negotiations, and we're going to focus on sentencing and how we can affect our clients, how the cases ultimately end for our clients. So starting with the coercion defense, this is the defense that currently exists. It existed before. It's an affirmative defense, right? And you establish the coercion defense if your client acted because of coercion, though coercion was a direct result of being a victim of human trafficking at the time the client acted. When the client acted, the client had a reasonable fear of harm. So basically, my client committed the crime because the client was a victim of human trafficking, and at the time, the client had a reasonable fear of harm, right? That's what you're putting forward. Okay, so now the question is what is the nature of the nexus between your client being the victim and the criminal conduct? And so we had a court weigh in on this, right? And the court said it doesn't require a showing that the accused was coerced directly by the trafficker to commit the specific crime. Fantastic, right? It does not require the trafficker to have direct involvement in or even knowledge of the client's crime. It is sufficient to show that the client has a reasonable fear of suffering harm as a result of the trafficker's scheme, plan, or pattern. And so basically what this court says is, look, the trafficker doesn't have to be involved in the crime. The trafficker really has to push the dominoes and push the ball that ends up and where the crime ends up, right? Because of the fear that the trafficker has really instilled, and because of the coercive nature of the trafficker's relationship with the trafficking victim. And so what did AB 124 do? Well, it expanded this defense to include all crimes except felonies defined in violent felonies. Originally drafted, this bill actually applied to all crimes, but throughout the process was whittled down by in various committees to expand and now encompass all felonies, including all misdemeanors, all felonies, including serious felonies, and just really the only exception now is violent crime, violent felonies defined in 667.5. And it changed the way we can use and put forward evidence to establish that your client is a trafficking victim. So prior to this, really, law enforcement has a responsibility to identify victims of human trafficking. And prior to this bill, we could use evidence of police reports. We can use police reports as evidence if the officer identified the client as a victim of human trafficking. But, you know, through practice, we know that's not always the case, right? There are times when we receive a lot of police reports about our clients, and our client is always with the trafficker. Our client is arrested along with the trafficker for a crime not related to some kind of sex offense, right? For instance, drug sales, drug possession, car theft, robbery, right? And so what this does is it says, look, this allows us to really put our client in a, like place our client with the trafficker for purposes of proving this. Like, look, every time this client's caught committing a crime, this individual is there. This individual is her trafficker. And so now we can use these police reports that document our clients with this individual in support of our proffer, you know, in support of this evidence we have that our client is being trafficked and that they shouldn't be held liable for this crime because they were coerced by the trafficker. So the coercion defense of 236.23, just victims of human trafficking. The newly added coercion defense of section 236.24 takes that defense and applies it to victims of intimate partner violence and victims of sexual violence, right? And so why is this the case? Well, it relates to identifying victims of human trafficking. It's no secret that victims of human trafficking will sometimes not identify as victims of human trafficking, right? They don't know it. They know it and won't say it. So it's difficult to really capture and protect that vulnerable population, those group of individuals who are being trafficked. It's difficult to protect them from criminal convictions, even though they're victims of human trafficking, and even though there's a coercion defense to protect them, right? And so what this now does is it says, look, sometimes it's easier to identify these individuals as victims of intimate partner violence or victims of sexual violence, right? Sometimes it's easier to say, look, this person was involved in a domestic violence relationship, right? And so because of that, and because of the nature and the power dynamics in that kind of relationship, this individual should also be excused from having from criminal liability. So what is coercion? Well, it's defined in Penal Code section 236.1 H1. And this is what it says. I'm not going to read it, but go ahead and take a look at it. So as you can see by the definition here, it covers a very broad, a lot of different behavior, right? That is coercive, right? So it's just not serious harm or physical restraint, right? It's extortion. It's threatening the legal process, right? It's holding someone, taking money from them, like keeping their finances, right? It's using drugs to coerce them to do something, right? Using their addiction to exploit them. And so be mindful of that as you approach these cases and identify your client as a survivor of human trafficking or intimate partner violence or sexual violence, that this coercive behavior really, it spreads itself out. It's hard to define as just one thing, because lots of types of behavior can coerce or exploit an individual. So this is something we came across a lot. On multiple occasions, various district attorneys attempted to say, look, we don't need a coercion defense because there's a defense or duress, right? That was kind of something we heard from district attorneys as we met with them to explain the significance of this law and why they should support it, because it's support for victims. And it's what we heard back from various legislators. You know, if we already have duress, why do we need this? So is it the same? And the answer is no, it is not the same. It is different. And I want to talk about duress. I want to compare these two so you can really understand and appreciate the differences. All right. So this is what duress is. It requires that someone's life, or a reasonable belief that someone else's life or the client's life is in immediate danger. All right. What is coercion? Well, we just looked at the definition, right? It is more broad. It covers more types of conduct. It does not require that someone else's life is in immediate danger, right? So in that respect, it covers a lot more type of victimization, or a lot conduct that victimizes other individuals beyond just a threat to someone else's life. So with duress, if there's substantial evidence of duress, the prosecutor has to disprove it beyond reasonable doubt. Okay. With coercion, it's our burden. So while it covers more conduct, it's harder for us to do because we have to put forward the evidence and we have to prove to the fact finder the coercion defense beyond a reason, by preponderance of the evidence. Okay, which means more likely than not. Coercion or duress can apply to any crime but murder. All right. Now it can apply to felony murder because it attaches to the underlying felony. That's why there's the asterisk there. Coercion, we already talked about, has limited applicability, right? Not violent felonies. If you're successful with duress, it's not guilty, right? That's what you get. Fantastic. With coercion, it's something I like to refer to as not guilty plus. For example, there are these ancillary benefits which are extremely important to our clients. Reports are sealed, records are destroyed, they're identified as a victim officially, and they do not have to even identify themselves as having been arrested or prosecuted or charged or acquitted in any future job applications. Duress is typically a trial defense, and coercion can be inserted at any time prior to the entry of plea, admission, or trial, right? So they're different. There is a place for both. Let's talk about negotiations, all right? Penal Code Section 1016.7. If any of the following was a contributing factor in the commission of the offense, the prosecutor shall consider it in support of a mitigated sentence. There is no option here. It can only be used to mitigate the sentence. One, the person has experienced psychological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or sexual violence. The person is a youth or was a youth at the time of the commission of the offense. Youth is defined in this section and for purposes of every section that was enacted by or amended by AB 124 as someone under 26 years old. And three, prior to the offense or during the commission of the offense, the individual is or was a victim of intimate partner violence or human trafficking. Okay. Once you identify your client as someone who is a survivor, and these circumstances apply to your client, if this circumstance and the nature of the victimization and the fact that your client is a victim was a contributing factor, the prosecutor has to consider it in support of a mitigated sentence. Okay, there's no choice. So moving to sentencing, the thing about the negotiations is it really doesn't force the prosecutor to give you a lower sentence, right? It just says the prosecutor has to consider it. I think there will be some prosecutors who are sincere and considerate, right? I think there are some prosecutors who will play it lip service. And so we have to be careful. And AB 124 wants to guarantee, the idea was The connection was if someone is a survivor and that is a contributing factor in the crime, they should not be punished as if they were not a survivor, as if they had never been victimized, as if they were not a youth at the time of the offense, okay? And so it enacted sentencing provisions to put this forward, to enforce this idea, right? Now, before we get into those provisions, I want to do an extremely abbreviated and brief and superficial and basic primer on felony sentencing, okay? There are two types. There is indeterminate sentencing law, okay? And there is determinate sentencing law. Now, indeterminate sentencing law is a life sentence, right? 25 years to life, 15 years to life. That's what an indeterminate sentence is. Determinate sentencing is when there is no life exposure, right? When they're just finite numbers. And the way determinate sentencing looks is there is a triad of imprisonment, right? There is a low term of imprisonment, a middle term of imprisonment, and an upper term of imprisonment. And so what this looks like is the penal code section will say the individual, if convicted, blah, 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 can be punished by imprisonment for a term of 16 months, 2 years, or 3 years, for instance, okay? 16 months being the low term, 2 years being the middle term, 3 years being the upper term, all right? So what does AB 124 do using this within this determining sentencing law scheme? Well, it really ties the hands of the judges and the DAs, okay? It directs the court where to start and how to consider this individual's victimization, right? It says, look, you have to do something, all right? And what it does is it does that by creating a presumption that the court must impose the low term if any of the following were a contributing factor in the commission of the offense. The person has experienced psychological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or sexual violence. Person is a youth or was a youth at the time of the commission of the offense, or prior to the offense, or during the offense, the individual was a victim of intimate partner violence or human trafficking. So it takes those same circumstances that district attorneys must consider in support of the mitigated sentences and says, look, if those sentences were a contributing factor, the court must start at the low term and can only impose something above the low term if the aggravating factors outweigh the mitigating factors, so much so that the low term would not be in the interest of justice. Okay, that's how it really creates this presumption. And I want to be clear here, it's important to note the coercion defense applies to everything but violent felonies. Okay, the negotiating provision, the provision that discusses and mandates this plea bargaining applies to every crime, everything. The sentencing provisions apply only to determinate sentencing crimes, okay? Okay. So looking at the statute, right, your client is a youth, survivor of trauma, survivor of intimate partner violence, survivor of sexual violence, we know that, right? And survivor of human trafficking, or a survivor of human trafficking, right? Now, when I first gave this training about AB 124, it was right after it was enacted, and I said, look, our clients are not clients, they're not defendants, they're victims, right? They're our clients, but we're not going to refer to them as clients, we're going to refer to them as victims. You know what? We need to go further, right? These are not just victims, they are survivors. These are people who have overcome life-endangering events. They have overcome harrowing circumstances. Despite those circumstances, they have come out living, right? They are here. They are breathing. They are with us. They are survivors of trauma. They are survivors of these terrible circumstances, okay? It's important to remember that. It's important to remind people, like, these are things that end people's lives, right? These are terrible things that crush people. And the fact that your client's here, despite their past, despite their current circumstances of a violent relationship, they are here in front of you, okay? They are breathing, they are talking to you, they have emotion, right? They have survived. Who are our survivors? Okay, they're our clients. But let's look at really the disparate impacts of trauma and really identify the differences or really the impacts on certain communities that trauma can have, okay? 61% of Black children have experienced at least one adverse child experience. 51% of Hispanic children have experienced at least one adverse child experience. 40% of white children have experienced at least one adverse child experience. Why? Well, according to the CDC, it's likely attributed to the uneven provision of services and opportunities in underrepresented communities. So these communities aren't getting fair services. They do not have the same opportunities. And there's a connection between that and the likelihood of trauma. What about sex trafficking? 40% of sex trafficking victims are Black, whereas only 26% of sex trafficking victims are white. 50% more. What about intimate partner violence? Multiracial people are most likely to experience intimate partner violence. This is according to a DOJ study. And Black individuals are more likely to experience intimate partner violence than white individuals. Because of bias, because of prejudice, because of discrimination, because services aren't provided to these communities, because they do not have the same opportunities, they are more likely to experience intimate partner violence. Individuals in these communities are more likely to have experienced childhood trauma, and in some communities, more likely to be trafficked. Okay, so we know that. How does this correspond to imprisonment in California? The rate of imprisonment for Black men is 10 times the rate of imprisonment for white men. The rate of imprisonment for Latino men, this is according to the study, these are the categories that the study put out, is twice the rate of imprisonment of white men. What does that actually look like? How does that translate, right? 4.2% of Black men in California were in prison in 2017. 1% of Latino men were in prison. And 0.4% of white men were in prison. The rate of imprisonment in 2017 for Black women was 5 times the rate of imprisonment for white women. So these individuals who are subject to prejudice and subject to discrimination, who are not afforded the same opportunities, the same chances, the same services, end up in prison at higher rates. More likely to be victimized, more likely to be imprisoned, in prison. Okay, so you've identified your client as a youth and or survivor. Now what? Right? Okay, well, we know looking at the statute that it has to be a contributing factor. So what is a contributing factor? Early on in the process, there was no contributing factor language. And I think rightly so, despite me not wanting the language in, I think rightly so, some people insisted, look, there has to be a nexus if this is going to become a law. They were absolutely right. Because throughout the entire process, people kind of criticized the lack of a nexus, right? And how this was too vague and we're not sure what it means. Well, the legislature ultimately decided it wasn't too vague and passed the law. So what is a contributing factor? So a commentator, we don't have a case opinion on this, right? A commentator who's pretty well respected by district attorneys and courts has put forward what he thinks this means. And this is Judge Cousins, that it's some connection however slight, in the commission or circumstances of the crime. I could not be happier with this opinion. This is exactly what we were aiming for. Look, this individual is a victim. That victimization or youth had a role in the crime. It's not the contributing factor. There may be no direct causal relationship, but that doesn't matter, right? Because we need to protect these individuals. We need to acknowledge that these individuals are more vulnerable and more likely to be victim or to end up in the criminal justice system, that they've been victimized and that they require and need special treatment. It's only fair. And so what this says is, look, you only have to prove that it's a slight, right? That there is a connection, however slight, in the commission or circumstance of the crime. So from the statute, we have learned two tasks, right? We have two tasks. We have to learn the information and we have to advocate with the information. Right? We have to identify our client as a victim. We have to identify our client as a youth, which should be fairly straightforward. We have to determine whether or not that's a contributing factor. And once we've learned that information, we have to do something with it, right? AB 124 says, look, this is what you should do with it. This is what needs to be done with it. This is what justice requires. Before we talk about how to do these things and effectively advocating for this, I want to talk about the why. Okay, why do we need to do this, right? And you're like, well, the law says to, right? Okay, we have a duty of competence, right? Competence under Rule 1.1 is defined as applying the learning and skill and mental, emotional, and physical ability reasonably necessary for the performance of such service, right? We got to know the law, we got to be competent in the law, and we got to use it to advocate for our client. We owe a duty of diligence to our clients. Diligence is defined as the commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to the lawyer. We have to learn this information and we have to use it. And if we don't do that, the law tells us to, right? And if we don't do that, we're neglecting our duty to the client, right? We're neglecting the matter it's entrusted to the client, right? And then we also know what the California Supreme Court, how they've defined our duties, right? We have a duty to zealously advocate. But it goes beyond that, right? Okay, so we have these duties. So what does that sound like? You know, oh, well, I have to do it, right? Well, I do it because I have to. Well, that's not enough, okay? Appreciate that what AB 124 does is says, look, learning that your client is a victim, learning that your client is a youth, and identifying that circumstance as a contributing factor will affect what happens with your client. There is no doubt in my mind that this information will affect what happens with your client. Even if the district attorney doesn't offer a mitigated sentence for whatever reason, okay? Even if you don't settle the case, even if it's not a determinate sentencing case, or you don't settle the case with a judge who imposes slow term, okay? Knowing this information and using this information will ultimately affect what happens with your client. Okay, so how do we learn the information? We're going to start with the easy one, records, right? We've all pulled records. Some examples of records where you can find this information: child welfare services records, school records, therapy treatment records, jail prison records, right? Hospital records. These are records that can demonstrate or show that your client has been victimized, is a victim of trauma, a victim of sexual violence, a victim of childhood maltreatment, a victim of domestic violence, you know, a victim of human trafficking. All these records can help establish that, right? There's lots of different kinds of records you can go. It's really only limited by your imagination, right? Where else? I think the best source of the information is you talk to your client. You talk to your client about this. You learn from your client. But it's not as easy as that, right? You don't just walk up to your client and say, hey, have you ever been involved in an intimate partner violent relationship? Have you been a victim? It doesn't work like that, right? You have to build a relationship with your client. Okay. Before any of this can happen, before you're identifying your client as a victim from the client's own mouth, maybe you've identified with the records, before you talk with your client about it, before your client wants to talk to you about it, you need to build that relationship. Your client needs to trust you, right? These are individuals who've been victimized, either now, when they were a kid, throughout their entire life. There is a trust issue, rightly so. People have hurt them. They need to be able to trust you, right? How do we do that? Well, we keep our promises. You know, I'm going to see you next week. I'm going to come and visit you. You have to visit them next week, right? I'm going to call you tomorrow. You have to call them tomorrow. I'm going to send you something, or I'm going to bring, you know, whatever it is to the jail next time I come. You have to bring it, right? You keep your promises. When you go to meet with the client, you talk to the client about what interests them, right? When you're on the phone with them, like, what, you know, let's talk. Let's talk, not about the case. You know, tell me about yourself. What's going on in jail? You know, have you talked to any of your family on the outside? How are they? Right? Talk to them about their interests. Get to know them. Care about what they say, right? Listen, be genuine. These are survivors, right? These are individuals who have overcome so much. They are interesting people. Be interested, be genuine, right? Want to know what they're going to say. You know, I said talk regularly, face-to-face visits. Let them see you looking at them when they're talking. Let them see you be engaged with them. Let them see you smile when they say something funny, or let them see you get sad when they say something sad, right? Let them see your emotion, because it tells them, look, I'm invested. I'm being genuine, right? It tells them this person cares, right? This person comes to jail, doesn't even talk about the case with me, and sits here for an hour while we, you know, talk about whatever. They care. So it's very important to build that relationship with the client. I'm not saying it's easy. It is extremely time consuming, but you know what? It's our job. It's time consuming and it's worth it. All right. You owe it to them. They've been victimized their entire life. You are here representing them. Build a relationship. Know them when you represent them. You have to be mindful about how you approach the trauma. It does not work to ask them, hey, were you abused as a child? Or was your life pretty bad as a kid? Or, hey, have you been in a lot of DV relationships? That doesn't work, okay? When you're going to approach this subject, you need to let the client know that you're going to talk about some difficult stuff, okay? But it's more than that. Get their permission. Ask them if it's okay. You know, I want to talk about some stuff, maybe not today, but in the future. Is that going to be okay with you? You know, when you start to talk about it, or before, say, look, if you decide you don't want to talk about this when we're talking about it, just say you want to change the subject. You know, just say, you know what, I don't really want to talk about it. And that's fine. We'll talk about something else. You know, I think you're an interesting person. We don't have to talk about that stuff. We can do it another time. If they're talking to you about these traumatic events, they're talking to you about how they've been victimized. You know, listen, watch them. If it comes to be that you're watching them and it's too hard or it's too difficult for them to communicate, or they're struggling, they may not tell you that they want to stop, but they really want to stop, right? They don't want to let you down. Stop it. You know, say, hey, you know what? This is real heavy stuff. Let's deal with this next time. Let's finish this conversation next time. Let's talk about something else now. I don't want you to go back to your cell, you know, thinking about this stuff. Let's move on, okay? Read the client, right? Give the question some thought. Think about how you want to approach it. You want to approach it, you want to be respectful of their victimization, respectful of their trauma, respectful of their circumstances. You want to understand that and appreciate it when you form your questions, right? This is something you need to think about in advance. When your client's talking about these events, this victimization, things that if they've happened to you, you haven't even shared with anyone else, right? The clients are sharing with you for the first time, or, you know, being brave, putting themselves out there, talking about something that nobody ever wants to talk about or relive. Listen carefully. Be sensitive to what they are telling you. Think about the words that they're using and that they're not using. Right? Our clients have learned to survive with what's happened. They've learned to move, to keep moving, right? To keep living. So be cognizant about the clues about, how they communicate. Look for clues about how they've survived with this, right? How they've dealt with it. Listen to their language. Watch their body language. Right? Try and understand what they're saying. And let's talk about some examples of the language that clients use and what they're describing and how they're describing it. So Dad had kind of a wild streak when I was young. All right. So eventually you learn, what does he mean by wild streak? Well, we'd have to physically intervene to get Dad to stop beating Mom. Once he tried to brand your client with a fire poker, right? That's not a wild streak, right? That's domestic violence. That's intimate partner violence. That's child abuse. That's brutality, right? My mom tried her best. How many times have we heard that, right? But from CPS records that Klein and Ted siblings, all under 10, were found alone at home with rotten food and human feces on the floor. That at one time, on one day, Mom left and never came home, right? Nobody wants to talk badly about their parents, right? Or very few. Maybe they come to a point when they can't. They always try to cover, right? Understandably, these people are their parents. She did her best. It's like, that's not doing her best. That's neglect. That's not fair to you. How about this? School wasn't fun for me. Well, what did that mean for this client? Well, he was bullied in school to the point of dropping out. That after he dropped out, he didn't go home and he slept on the streets and started smoking cocaine at age 15. That's not school not being fun, right? School isn't fun when you have to do homework, or school isn't fun when you get detention. Bullied to the point of dropping out is something else, right? That's psychological and physical trauma, right? Turning to drugs at age 15, cocaine at age 15, that's something else. How about this? He would touch me, but he was always drunk when he did it. An excuse for child molest. An excuse for sexual violence. My partner came home high once and forced me to have sex with him. But that was only once, minimizing the behavior, right? This is not, these are not made up. We've all heard this. This is how your clients have dealt with it, right? This is how they have compartmentalized it and minimized the damage that was done to them, right? It was only once that this happened. And it's like, that was one time too many. Empower your client. This is the time. Your client's sharing these with you. It's a time to tell your client the hero that they are, right? You survived this. These things would crush people. These things do crush people. These things have crushed people so badly, they've ended their life. They've never told anybody about it. It's ruined relationships. Yet you are here, you're talking about it, you've survived. Encourage your client. Tell your client you are worth it, right? I am here, not because I have to be, because the state bar says so, right? I am here because you're worth caring about. You're worth caring for. And you need to know what a powerful person you are. There are very few people in their lives, if any, that have ever told them that they are a hero, that they've survived things that people do not survive, that they have been victims of the worst type of behavior. And sometimes you have to accept as the lawyer that a client will never tell you what happened, how it has affected them, or how they cope. A client may never share it, right? But sometimes they tell someone on your team. And that's great. Someone on your defense team has earned their trust. Maybe you have their trust, but maybe they just don't feel comfortable. Maybe they never want to talk about it with you, but they talk to this other person about it, right? For whatever reason, there's a connection there. Fantastic. Okay, that is wonderful. Accept that that may be how it is. Also, accept that they may never tell you. They may never want to tell you. Despite you knowing it, right? Despite you having read records about it, read reports where they've told other people, law enforcement, COs, social workers, despite having told them about it, they never tell you about it. They don't tell your investigator about it. They don't tell co-counsel about it. They don't tell your mitigation specialist. They don't tell your paralegal, nobody, right? You know it's there. It's okay if they don't tell you. Look at the words of the statute and recall what it is. The victimization alone is enough. Hearing from your client and witnessing it from your client and witnessing them tell you and sharing it and learning how they've dealt with it firsthand, that is powerful. And that will make you a better advocate. But if that doesn't happen, it doesn't mean you can't advocate. It's their status as a youth, or their status as someone who's been victimized, or their status as someone who's in or was a victim of intimate partner violence, or is or was a victim of human trafficking, that qualifies them for the relief under AB 124. Okay. The very existence of them being a victim is enough, even if they don't tell you. Beyond the client, sometimes we identify and talk to individuals who are informed about the trauma. In fact, I encourage you to seek out and identify individuals who know about it. Now, who might that be? Here's some examples. Family members, right? Aunts, uncles, sisters, brothers, teachers, social workers, childhood friends, former significant others, people who have witnessed your client, the manifestation of this victimization. Your client has shared it with them and they've watched how your client reacts to it, or just, deals with it. They'll talk to you about it, right? Neighbors, sometimes more often than not in these domestic violence cases, it's the neighbors calling the police, right? And the police show up and your client's there with a bloody nose, having wet their pants, having been strangled with marks on their neck, black eyes, and they're telling the police repeatedly, nothing happened. Nothing happened, nothing happened. And it's the neighbor who heard it, right? Or it's the neighbor they confided, right? So you look for people who may know, people who your client has reported to, or people who may have witnessed. Talk to them about it. They can be your historian. So now that you've learned the information, it's time to advocate with the information, okay? You have to connect the dots. I don't know why it's not self-evident that that kind of victimization and that kind of trauma and youth, that it's not self-evident that that obviously has some factor in the alleged wrongdoing, right? In the alleged criminal behavior. I don't know why that's not the case, but it's not. It's your job to connect the dots, okay? Remind the criminal justice actors of what a contributing factor is. Remember, it's some connection, however slight, in the commission or circumstance of the crime. Your connecting the dots is you establishing that connection, a connection, however slight, in the commission or circumstances of the crime. Need to know your audience. Who is your audience? They're district attorneys, prosecutors, and judges, right? There's this phenomenon in chambers where, despite knowing what your client's name is, sorry, my lights went off. Despite knowing what your client's name is, refer to your client repeatedly as the defendant, right? Refuse to call your client by name and call your client the defendant. Some prosecutors will refer to your client by name, and let me tell you, it is so refreshing. But some refuse. Defendant, defendant, defendant. Oftentimes in chambers, the first thing that they talk about after the crime, the facts of the crime, according to the police reports, is your client's criminal record. So before you've had your piece, the judge knows what your client's accused of and knows that your client has a criminal history. There's skepticism about trauma, right? And what trauma does. Explanations for conduct are sometimes minimized as excuses or defined as excuses. There's demands for prison, right? You'll hear from certain, judges like, look, I hear this every day. This is everybody that comes through the criminal justice system. It's like, yeah, that's true. And I don't think it's a coincidence. You hear sometimes that, look, your client was given a break last time when they got probation. So really, why do they deserve a break this time? Right? So know your audience, right? These are individuals who have been in the criminal justice system a long time, dealt with a lot of cases, right? Who are dealing with a lot of cases. So we have to discuss the statute. It's like, look, I get it. You hear it all the time. And I get it. You think that probation grant last time was chance. But we're not in a position right now to say this doesn't matter, right? This legislature has told us, has said, this matters. You have to consider the victimization. It is related to the criminal conduct. It is relevant to the determination of what this individual should be sentenced for if they're convicted. And you need to consider it because they've already determined it's relevant. Use the statutes, right? Use the legislative history, the bill information, right? Put that out there. Look, Judge, I understand that this is a lot of people in here. And you know what? That's why the legislature said it's so relevant, because so many people in the criminal justice system have been victimized and then charged with a crime. Hire and actually use an expert. Okay, this is more than just getting an evaluation. All right, I'm getting a psych eval. That's it. That'll take care of this, right? That's not enough. All right, you need to put some thought into who you hire. Right? Think about it. At the point you're hiring an expert, you know something about your client. Ask yourself, will this client feel comfortable with this person? The doctor you're thinking about is male. Ask yourself, is this client going to be comfortable talking about these things with a male doctor? Is that going to be something that's going to work, right? Is this client going to be embarrassed to talk to a female doctor about, right? Is this client going to be embarrassed to talk to an older doctor about it or a younger doctor about it? Like, think about it. How's the client going to react? And then ask yourself, who is this expert? Will this doctor be empathetic when they talk to my client, right? Get to know the expert, talk to the expert. These experts are well-qualified individuals, well-educated individuals, and they have their niches, they have their strengths, they have their weaknesses. Know them, evaluate them, right? Talk to the expert about the goals of the evaluation. Inform them what you're looking for. Inform them what they should be looking for, right? I want you to look at and see if this individual's childhood trauma actually had an impact in this particular case, right? Or if it is something that needs to be considered, right? This is what I know about my client's history. When you talk to them, look for that, right? Ask for copies of the studies your experts have relied on, right? Read what they read. Follow up with the expert. Talk about your expert and their qualifications and their findings. If you choose to disclose that expert evaluation, throw the expert's weight around in chambers when you're negotiating, right? Like, look, sometimes we have situations where lawyers and judges are diagnosing our clients, differently than the expert. And it's like, you know what? A JD lets you do a lot, but it doesn't let you diagnose a client, right? It doesn't let you diagnose someone. It doesn't let you tell me how trauma has affected someone, right? So talk about your expert. Develop a narrative, okay? You need a way to communicate your client's history, right? You've gotten permission from the client to talk about it. You've gotten permission from the client to use it. Now you need to put it in language we understand, right? You need to put it in language that people can digest, right? This is like, you make it personal, but you don't make it personal. Here's an example, right? People love to talk about where their kids are going to college, right? And education achievements. It's fantastic. They should be proud, right? People value education. They work hard at becoming educated and getting certain places. Now, since we know that, man, it must be really difficult. Imagine like not being interested in enough in your client, in your son or daughter or child's life to encourage them to go to school, right? What do you think would happen? Imagine that kind of life. Imagine not caring if they did their homework or not even being interested if they went to school, not taking them to school at age 6, at age 8, at age 12, right? Not caring that they dropped out. Imagine being a parent and feeling that way. What must that be like for the child, right? That's things that people can identify with. Like, wow, I can't imagine a life like that, you know? Or a lot of our clients, it's terrible, have been exposed to drugs by their parents, by people they look up to, when our clients are 12, when our clients are 10, right? So, you know, bring it up and put it in language we understand in chambers, right? I mean, Judge, can you imagine your father handing you a meth pipe when you were 12? Can you imagine handing your 12-year-old a meth pipe? Like, what kind of relationship is that, right? What would that do to your kid? What would that do to you, right? And it's like, you know, that kind of stuff hits home because it's like, you know, you hear it, you read it, and your clients tell you, you know, you read their drug history and probation reports, like started using meth at age 12. That's the end of the sentence from the probation officer when they write that in the report. And it's like, are you kidding me? Methamphetamine at 12 years old? Where did they get it? How did that happen? What did it do to their brain? What did it do to them? Develop the narrative, right? When you develop the narrative, make people admit it, right? And accept the narrative. Talk about it as much as you can. Argue it. Like I was talking about, ask rhetorical questions, right? Like, can you even imagine a world where you're handing your 12-year-old a methamphetamine pipe, telling them to smoke meth with you because it'll be a fun night? Like, can you imagine that world? Of course not. Argue it, right? Argue it in chambers. Talk to them about it and be passionate, right? It's okay to be passionate. You know, I'll admit there's a couple times I've become unglued during chambers when we're talking about this stuff because, you know, various people in chambers dismissed things. You know, I once had a client who was a victim of intimate partner violence, currently in a relationship where she was repeatedly abused and suffered from severe depression. And I was met with the response of, well, I mean, everyone's depressed. And it's like, no. Like, no, that we're not talking about that. Like, we're talking about someone who is in a relationship defined by intimate partner violence, who is routinely beat, who is severely depressed, right? Like, that's not just, oh, everyone gets sad, Judge, right? It's hurtful. Like, things like that are tough, right? So it's okay to be passionate. You meet with your clients, you witness the trauma that they've sustained and the manifestations of that trauma. You see how broken some of them are. And you want to impart that to the criminal justice actors, right? Be respectful, obviously, right? Never be disrespectful. But it's okay to be passionate. It's okay to put yourself out there, right? But I would be remiss if I didn't talk about it will come at a cost, right? Like, this is heavy stuff. This is terrible stuff, right? You are hearing about crimes that have been committed on your clients that are horrific, right? The worst things you can imagine, the worst things you can possibly accept. And so you need to be cognizant of how you are dealing with this, right? Like, here, the other night, I left jail and I came home and completely unloaded on my wife about how unfair the criminal justice system is, how it is, how this is completely unfair, how I can't believe it, right? How this person's life was totally robbed of this, my client was robbed of the client's life through no fault of her own when she was a kid. Then, after ruining my wife's night, who obviously understands and agrees, I proceed to fill my co-counsel's and friends' text message inbox with a bunch of texts saying the same thing, right? giving her a bunch of anxiety that night, probably ruining her night, right? Not a healthy way to deal with this, right? But it's overwhelming. You're hearing about terrible things that have happened to wonderful people and they've survived. And now they're in the criminal justice system. And maybe they've committed a crime, right? And maybe it's a very serious crime. You can acknowledge that. But at some point, you're witnessing the humanity of someone who's been hurt and has survived. And it's very difficult. So be aware, right? Be cognizant of how things are going. And then I'll end with this. This is change, right? It's 2022. There is finally a law on the books that requires the criminal justice system to consider the impact of victimization and crime on criminal behavior, on your client's behavior, right? For the first time, there's a law that says it matters, it makes them less culpable, and you need to acknowledge that and appreciate that and do something about it, all right? This is change, and it's going to be difficult for people to accept this change. Encourage them. Do not accept, do not be okay when they are dismissive, okay? But be respectful. Learn how to communicate with the other criminal justice actors, right? Learn how to explain to them so it actually you can be persuasive on behalf of your client and so that you can effectively advocate for your client. Reach to their humanity and explain why it's so important, right? Try to be understanding. And that's all I have. And I want to thank everyone, and I can answer any questions if there are any.
Thank you, Jeremy. We're so grateful to have had this training. Thank you, everybody, for being here. I do want to add that Jeremy taught us a lot of things in an hour, and I'm sure that each of those buckets could have taken an entire hour just by itself, right? So if there are any specific things that you wanted to hear more about and we didn't get a chance to go through in more detail, please let us know and we'll be happy to give you more resources or see if there's enough things for us to plan a second training on this. I'm adding my email address and our website as well that also has additional trainings. This is heavy, heavy, heavy work. And we are so grateful for each of you who is doing this work, who is involved in helping people and making people's lives better. But please take care of yourselves. Please do something to support the people on your team and make sure that we're taking care of each other and protecting each other as we do this work. We also want to acknowledge the fact that not all the language that we're able to use in these technical trainings is going to be as trauma-informed as it should be, right? And we know that, we realize that. However, there's this disparity in the language that's used in statutes, that is used in courtrooms, and what prosecutors and judges expect to hear and what they use. So a lot of the language that we used is based on that, and we understand that it is not the most trauma-informed language. It does not fit the bill for every survivor and every single victim situation, but know that we're constantly working on that, and together we need to make those changes as well in our laws and in our systems. Let me just see if we have any other questions. I don't see any other outstanding questions. If you think of anything, please contact us and we're happy to send you any further details or information. Have a wonderful, wonderful day, and thank you for joining us today.